What is the difference between trademark, patent, and copyright under Nigeria law? And what's the similarity as well? The major similarity between three of them is the fact that trademark, copyright, and patent, they are all forms of intellectual property to protect intangible assets of individual creators. Trademark, to start with, protect words, symbol, logo that are used in marketplace to distinguish one product, one services, one goods from another. Meanwhile, the patent is a form under Nigeria, is a form of a mechanical invention where someone has invented something mechanical and unique that are not yet in circulations. So patents, you can't patent an idea, thinking of something alone, it can't be patented. You must have gone through a form of invention. You must have created something. It could be the invention could be an advancement on something that has already been created. So patents are made to protect the inventions. Copyright. Copyright is the most popular. Everybody knows copyright. Copyright, they are those rights that the creators, the artists, they automatically derive upon producing or making any copyrighted work. What are the copyrighted work? Music, sound recording, books. The authors, they automatically own a copyright to their books. So the copyright also is a form of intellectual property that protects the works that are subject to copyright. The most popular ones that we all know are movies, theater, recordings, music, and of course books. Those are the world major most popular copyrights. Now, evaluating three of them under Nigeria law, two of these forms of intellectual properties, they are registered at the Office of the Trademarks, Patents and Designs Registry in Abuja, while the copyright is registered by a different commission, which is Nigerian Copyright Commission. Now, looking at three of them, trademark, as they may say, it may not need to be registered, but it is important to be registered. If a trademark is not registered, the owner of the trademark might still enforce its right under a provisions of law that we call a sort of passing off. But this is not advisable. All the owners of a trademarks are encouraged to register their trademark, because it is when registered that those trademarks can actually be fully protected and where third party can be stopped from infringing on such a trademark. However, a copyright, it may not be registered, although several international and modern ways of doing business require that copyright should be registered too, to fully protect the artist. But copyright by law, under our law, it may not be registered. An artist or an author automatically derive or gain a copyright on a work immediately those works are created automatically. Then we talk about patents. Patents, which is an invention, it must. Now I talk about initially trademark that it may or it may not be registered, but it's so important that it should be registered. Copyright, it may not even be registered. Either registered is not registered, the author or the artist are still fully protected. But patent is different. Patent must be registered. You can't prove a patent. You can't create a patent right without registering those patents. Patent must be mandatory registered. For the same office that handle the trademark registration is also the office that handle the patent registration. Now, in closing this, what are the duration of these three forms of intellectual property when registered? Trademark, when registered, at the first time it expires in 7 years, but the owner has a right to continue to automatically renew it. When it's renewed, after that 7 years, it will be renewed for 14 years and can be continued to be renewed in perpetuity, continuously. Copyright, like I said, may not be registered, but assuming it is registered, it has been registered, and as it's most copyright, it depends on the type of copyright, but the most common one, the author, the artist or the authors, they have those right of copyright in their entire lifetime, and for a very obvious reasons. Like talk about musicians, there's nobody can come around when that musician is still alive might want to claim any right in that person's work when he was still there. So the most copyright that is produced in form of, let's say, music, book, and all that, the life through the entire lifetime of the author or the artist. Then after the death of the artist, some 50 years, 70 years more, after even the death of the artist, the maker of those copyright, of those works that is copyrighted. Patent is straightforward. It is valid for just 20 years from the day of registration. It is valid. After 20 years, it expires. The invention goes to the public, so other members of society can also work on it, and that's how society develops. However, despite the fact that the patent lasts for 20 years, it must also be renewed annually. We call it annuity. You must be informing government in form of a renewal annually. It's a token. It's a small money to just show that you are still keeping this right. You are still on this patent. You are still renewing it, still own it, you still have much interest. Because if you do not show much interest in the patent, members of public should be allowed to work on it without even a cost to you. So the annuity is a form of showing your intention to government that you are still much interested in your patent. But regardless, either you show interest or not, after 20 years, a patent must be automatically expired and goes to the public. Thank you.